to the Law, Borders, and Speech Conference, hosted by the Stanford Center for Internet and Society. We are a public interest organization focused at the intersection of law, science, and technology, and we work specifically on how to advance the rights of internet users, how to advance innovation, how to set wise policy that will make the internet everything that it can and should be, or keep it from becoming worse at least. We are gathered, I am Daphne Keller. I'm the Director for Intermediary Liability here at CIS. I bizarrely previously had the exact same title at Google. I was Associate General Counsel and Director of Intermediary Liability there, and in that capacity saw notice and takedown questions from all over the world that teed up many versions of the jurisdiction questions we will be asking today. We are gathered here today to celebrate the anniversary of the very prescient 1996 Law and Borders article written by our guests, David Post and David Johnson. So we are very lucky to have the men themselves here to talk about their work and what they think has changed. And I will submit that not that much has changed. They identified very important open questions in 1996, and I think what happened with the law since then on the question of national courts asserting jurisdiction to control content on the global internet, what happened was a chart that maybe went like 1996, 2000 hits, and you've got Yahoo France, and maybe the Dow Jones v. Gutnick case in Australia is right around then, and then it just plateaus for a long time. There was a long period where the law didn't change significantly on the question of cross-border speech regulation. But that period is ending right now. If the chart went like this, now it is the hockey puck moment, hockey stick moment. Because we have famously not only the right to be forgotten case in France, asking the question of whether French regulators can appropriately compel Google to delist search results around the world, we also have the Equistet case pending before the Canadian Supreme Court, which I know a number of people here submitted amicus briefs in, or participated in litigating, which also asks the question, when can one national court control access to content on the internet all over the world? The outcomes of these cases matter a lot. They matter to protesters in Ethiopia who were able to use the internet to let the world know about brutal crackdowns there. They matter to gay teenagers in Russia who are able to use the internet to hear 1,000 voices telling them that things can get better. It matters to the reporters who broke the Panama Papers story, who were able to speak truth to power and bring to light important facts by using the global internet to transmit information against the wishes of powerful people, including people in government. The outcome also matters to democratic countries with democratically created laws which they want to enforce. It matters to countries that wish to keep child pornography outside their borders. It matters to countries that have set a certain set of copyright rules and don't want piracy to be enabled by content seeking through the permeable borders of the internet. It matters to France in the right to be forgotten case, which I think is a very good illustrative case because it has both a high-level conflict of values and a very detailed and difficult set of doctrinal legal questions. The high-level conflict is there are people in France saying privacy is fundamental to us. The protection of our rights is only enforced effectively if this content that violates it becomes impossible to find. It is not okay to just take it down a little bit because this is a matter of our rights. And on the other side, you see people in America, including Latin America, saying it is extremely important to us that truthful content be protected by law, be made available, that we have a right to remember and not just a right to forget. So there's a high-level conflict of values, but it's embedded in the case as a dispute over some forgive me, data protection lawyers, but some very arcane points. Sort of, what is a processing? What is a single processing? You know, when is someone established? What is effective and complete protection? Terminology that won't necessarily be useful in answering the same big questions in the next big jurisdiction case, if that case is about defamation or copyright or some aspect of speech regulation. So I think the upshot is that courts may not have the tools they need to really approach these questions well. There is a great need for a public conversation among the kind of people we have here today to help advance that conversation, to help answer those questions. And I think this event will be a real opportunity to actually try to answer questions. This is, for me, an unusual conference in that I don't think it's full of people who are here to recite a well-rehearsed position that they've recited at 100 conferences before. I think many of us here are honestly here to learn from each other, to have a conversation, to come up with new ideas, to figure out new ways to move the law and the public policy forward. And when I say that, I'm referring not only to the invited speakers, who are an amazing group of people, but also the audience. We have many people in the audience who could just as easily be up here talking. You guys are all rock stars. When I set out to invite people to this, it was kind of like inviting people to a wedding. I was like, who would be the most fun? If I can have just one big party or nerdy conversation, who do I want in it so it will be the best possible party / conversation? So here we are. This came about thanks to the work of a lot of people who deserve thanks and credit. Elena Dolfo is probably out there somewhere making sure that things get done. Amanda, who most of you have interacted with also, is probably not here to hear my thanks because instead she's making the conference work. We also owe great thanks to Google, which financially supported the conference, and to CIS generally, and to you all for being here. And so with that, we will get the party started and kick off the first panel. I have the privilege of moderating this panel, sort of, which means saying who they are and then stepping aside and letting them talk. But I will very briefly introduce the panelists. Everybody here has too many credentials to list, so I am going to be brief, but know that they've all done much more than I can say. We have David Post, professor of law, retired from Temple University School of Law, and one of the two authors of the Law and Borders piece, whose anniversary we are celebrating today. We have David Johnson, other co-author of that piece, who practiced for many years at Wilmer, who taught cyber law at NYU, who was with CDT and on the board of EFF, has been sort of everywhere in this conversation. We have Bertrand de la Chapelle, who is probably the man in the world who has done the most to advance discussions of law and borders and how to deal with them. So we should definitely listen to him. And if you are not on the Internet and Jurisdiction Project mailing list, which he runs, you should get on it right away. Andrew McLaughlin, who has been everywhere from Google to the White House to Access Now, and who can speak eloquently about both the company perspective, civil society, and government perspective on these issues. NICOLE Wong, who has been even more of everywhere. Google, White House, Twitter, figuring out security issues for the DNC, and who we're very fortunate to have here today. And finally, Paul SIEMINSKI, the general counsel of Automattic, who has blogged in wonderful detail and nuance about what you can do as a company when you receive removal requests that are not consistent with the values of your company or the law of the country in which you operate. So each panelist is going to talk for about 6 minutes, and then we will switch over to some discussion. Take it away, David.
Thank you. Great, very nice to be here at Stanford again. I was going to use my 6 minutes to summarize everything that has happened since we published our paper, but I'm going to let David do that. I wanted to get things started, I thought, by looking back actually at the paper and sort of thinking a little bit about what we got right and what we got wrong. Rereading the paper carefully, which I had not done in many years, was an interesting exercise. I've heard it said that hell is the place where, right, Joe knows this, where you, knowing what you know now, you get to relive your life over again, but you have to make all the same choices you made the first time. So reading, without the ability to edit, you see a lot of stuff in there that I would have changed. But anyway, one thing we got right, I think, the original working title of our paper was Taking Cyberspace Seriously. And in our defense, by way of context, the conference we came to at Stanford in 1996 was not about cyberspace or the net. It was about law and borders. And it's what made it really so interesting. There were papers on municipal government law, on zoning, on international environmental law, on the geography of authorship, and quite remarkably, I had forgotten this till I looked back at the journal, there was the paper on reinventing the US-Mexico border by Edward Soho, who was then the US Attorney for the Southern District of California. Worth looking back at that one. And cyberspace and the internet and all that was pretty unfamiliar territory back in '96. So one of our goals was really just to suggest, to sort of wave our arms in the air, and suggest that the net, and more specifically, the difficulties of mapping physical borders onto internet communications, the startling new geography of the internet where all points are equidistant from all other points, that this will be both important in the years to come and a very difficult challenge for a legal order that is grounded fundamentally in physical territory. Cyberspace radically undermines, we wrote, the relationship between legally significant phenomena and physical location, and subverts a system of rulemaking based on borders between physical spaces. And I think we got that right, actually. I think that is still true. A second thing we got more or less right, some might argue more or less, that some of these problems become more tractable and become easier maybe for the world's legal system to digest if we forego the ultimately futile task of trying to determine where things happen when they happen on the internet, and accept that they happen on the internet. That it will be easier to address harmful activity on the net, not by trying to determine whether a website operated out of Slovenia is infringing a trademark in Nebraska, but by recognizing that the global network itself is a legally significant place, like Slovenia or Nebraska. And we were more or less right. And we went on to talk about the legal institutions, the rulemaking and rule enforcing institutions that could develop in this new place. And the actual title of the paper ultimately was The Rise of Law in Cyberspace, and we were talking about how law would arise. We were not, to be candid, I do want to be candid, we were not terribly clear about how this would work, and to the extent we were clear, I think we got a lot of it upside down and wrong. But we were groping towards a view of law and lawmaking on the net that I think still remains a very useful frame for thinking about the issues, a view that law and lawmaking will operate in two very different ways at two very different levels on the net. Some law on the net will apply across the entirety of Nebraska, as it were, across the whole internet. Laws to which all user communication is subject, whenever and wherever it crosses the border into cyberspace. Now, this is all just engineering stuff. This body of law, what Larry Lessig called West Coast Code, comprises the protocols, the standards, and the rest of the technical architecture of the net. It doesn't matter where your message enters the net. If it's on the net's message length rules and addressing rules and port allocation rules and all the rest have to be complied with. This body of law invokes what Bertrand several years ago called governance of the internet. And the institutions involved are, to many of you in this room, I'm sure, the familiar acronymic alphabet soup of the Internet's technical coordination ecosystem, the IETF. Well, no, really? That's really crazy. Okay. The IETF, ICANN, IANA, and the rest. At the other end of the spectrum is what Bertrand called governance on the Internet. The rules and regulations for applications and services that run on top of the physical and logical layers, and the behavior of Internet users deploying these applications and services. And this is, of course, where all the interesting stuff is. This is where the fun stuff is, at least if you're not, for those of us who are not engineers, so I guess find the first questions interesting too. Because these are questions about meaning and purpose and intentionality and values and the content of communications, not just the port that's being used or the number of bytes in each message. These rules don't apply across, or don't have to apply across the entire Internet at all. Indeed, given the diversity, the world's peoples have very different attitudes about these matters, about fraud and defamation, trademark infringement, pornography, hate speech, incitement, and all the rest. These rules surely shouldn't apply across the entire territory. And I think the challenge is really that we try to identify, and that is still with us, is how to retain this diversity of rules in an environment where the borders which help to maintain that diversity in real space are very difficult to perceive. So in the 13 seconds I have left, the 11 seconds I have left, I want to just plant a stake in the ground because it's too complicated to talk about in 6 minutes or less. And the stake in the ground is this. We're going to spend most of our time talking about, I'm sure at the conference, this second set of issues, this governance on the Internet, the rules, content rules, and the diversity in different places. Interesting and important questions. The stake I want to place in the ground is about the other level, because I think the governance of the Internet level, precisely because the jurisdictional problems have been so difficult to resolve, there has been increasing pressure to use the instrumentalities of governance of technical architecture for the governance of content and meaning and all the rest. As you all probably know, a few weeks ago, we turned over control to ICANN. ICANN is now a truly self-regulatory institution. It will be under extraordinary pressure to use these levers of infrastructure control to address questions more appropriately, I think, left to the content layer, questions about content, about message meaning, about infringement, et cetera. I'm told, I know Daphne's going to kill me if I continue, so I won't. So I hope we will get back. We'll get back to that. Even though we're talking about these other issues, I don't want to lose sight of this one particular set of questions governing the role of law in content control on the net, and I'll turn it over to David.
Thank you. One of the papers that was at the original conference, which you didn't mention, was a fascinating paper on Icelandic law, polycentric law, law without a state. And I'm going to suggest a particular way of thinking about the conflicting sources of law that might apply to particular cases online. I mean, we have to think about what law is. Law comes from a polity. And we have various different polities with different values and so forth that are affected by what happens on the net. So the question is, what do you do when you're confronted with competing, inconsistent claims by particular sources of law, whether states or other sources of rules, like the terms of service of a global platform, like Facebook, for example, claiming to be the right source of the rules to govern a particular set of speech or decide a particular case. But I think we have a good answer to that from Paul Schiff Berman in his work on cosmopolitan pluralism. His argument is that regardless of the fact that they have different values and inconsistent rules, different sources of law can all agree, should all agree, it's a normative claim, to defer to whichever source of law, whichever jurisdiction has the strongest argument that it has the relationship with the case at hand that entitles it to be the one to make the rules. This is a lot like the doctrine of comity that we did discuss in our paper, but it applies not just between states, but also between other kinds of sources of rules. And states, in fact, defer to private enterprises and organizations, to religious organizations, all kinds of polities that govern their own affairs and that have a stronger claim to make the rule about what happens inside a company or what speech is permissible inside a religious context and so forth. So, what are the kinds of arguments that can be made? This kind of contest between claims to make the rules in a particular case depends on the case in question, but it's clear that simply having the power to control things is not enough. Simply having property rights over a technology that could be used to control things is not enough. We mentioned in our article various other kinds of things that might have some relevance, like notice, where the effects fall, whether something is enforceable, and so forth. But I think the two most important elements of the arguments for deference to a particular source of rules are congruence and consent of the governed. By congruence, I mean the extent of the overlap between the people affected by a rule and those whose well-being is taken into account when establishing the rule or applying it. We discussed congruence in another article called Chaos on Every Continent, and I think it's very important when we're thinking about how to govern activity online that we ask ourselves, is the state or the private company that's attempting to be the source of the rule here, is it taking the welfare of those affected by the rule into account to the maximum degree? And the other obvious point here is consent of the governed, because that's a critical source of the legitimacy of any rule of law. In that regard, I think we have not yet been nearly innovative enough. There's an interesting new book called Beasts and Gods by Rosalind Fuller that contrasts the Athenian model and the Roman Republic model. Our US founding fathers, of course, looked to the Roman model involving elections that have all the problems that elections have, including the potential to be influenced predominantly by money and so forth. In Athens, Fuller explains, most of the public decision-making was conducted by people who were selected by lottery and were paid a living wage to serve in these offices. So you got something more representative of the polity in question, if you will. One other possible thing we could do, and David and I have suggested this in another context, with regard to large, powerful online global platforms, is to innovate in ways to allow the users of those platforms to have a greater say in terms of service. My understanding is that Facebook did at one point say they would not roll a change of terms of service if the Facebook users objected, which everyone did, but they said there would have to be a third of the users giving their opinion, which of course didn't work. We suggested that we should create a new system by which anyone could give a revocable, transferable proxy to someone else. I would give mine to David, who could then transfer it on to someone else, and you could end up with a relatively small number of people, 20 or 100 people who collected the most proxies from users and who continue to speak on their behalf unless somebody along the chain revokes the proxy. And so we could use the technology to produce a meaningful way for the people affected by speech rules to express their values and decide, and perhaps have something a little bit more like consent of the governed online. Now, building that technology doesn't have to be done by the platform in question. Maybe Google should be building the Facebook Users Union Hall, for example. So that's my suggestion for how we could go about thinking about this a little, just to conclude, some are going to say we should always prefer the rule that minimizes the regulation of speech. That would be like imposing a First Amendment kind of regime on the internet. I'm not saying that. I'm saying what we should be doing is maximizing the congruence and the consent of the governed, so that when any given controversy occurs, we have a better sense and general agreement as to whose rules ought to apply. Bertrand.
Thank you. It's always a pleasure to be here. For those who don't know me, I'm Bertrand Chapelle. I'm the Executive Director of Internet and Jurisdiction, which is a policy network trying to address those issues for about 5 years now. It's easy to say that what we're discussing here is a pretty complex issue, and so I will try to use a few simple ideas to frame this problem along the lines of a paper that we produced for the Global Commission on Internet Governance, and the title was Jurisdiction on the Internet. Thank you, David, for the mention. From legal arms race to transnational cooperation. And as I like structures, because I'm French, there are 4 elements in this title, which will allow me to structure what I'm saying around those 4 elements. When we're talking about jurisdiction, rapidly, I don't have to explain this here, but it's basically who sets the norms, who does it apply to, and who adjudicates, roughly. I mean, there are other definitions, but the great thing about the Westphalian system that has, after all, worked for about 400 years is that it simplified drastically this problem. Because of the polities that are defined by territories, we killed hundreds of millions of people in order to define exactly where the territory finishes and starts. And in that framework, you have the monopoly of determination of the rule by the government or the state, the monopoly of enforcement as well, a very clear polity, which is the citizenship of the people who reside in there. Everything is very nice, very simple. And it's working perfectly because the international system that we live in is based on the separation of sovereignty and the principle of non-interference. Very nice picture, point 1. The problem is that, point 2, when you get to the internet, everything is, not everything, but a lot of things are changed. Fundamentally because the architecture of this network is, as we've said over and over again, non-territorial, even if there are some elements, but roughly speaking, it's not based on territorial criteria. And more importantly, because the services that are enabled by the internet are cross-border by nature and particularly allow speech across borders in ways that were absolutely unavailable before. And not only available across borders, but in massive amounts. It is billions of posts, pictures, and so on. And so, to go along with what was just said, the challenge that we're confronted with is what could be called normative pluralism, because at the moment, you had the monopoly of edicting the norm by governments. But it is true that the major companies are actually producing norms regarding their own users. I don't know if they are a polity or if the community is a polity, but the reality is that for anybody who uses one of those platforms, the terms of service or the community guidelines represent the law of the digital space or the digital territory. And so we thought for a while that actually freedom of expression was protected by the absence of regulation. The reality is that it is a proliferation of regulation at the moment. And it is a conflict, not only a conflict of law, but it is a competition among powers on who is actually applying its norms. But more importantly, it is not because people are ill-intentioned. It's because the fact is that the courts and everybody has recognized progressively that the national laws should be respected, at least to a certain extent. Remember that initially, the problem was solved very easily. People were saying, who had companies, and said, I'm sorry, I'm based in country X, therefore, in my terms of service, it's the law and the courts of country X that are competent, period. And by the way, for those of you who know the domain name space, this is still the behavior, and I'm not saying it's right or wrong, it's still the behavior of most of the DNS operators, the registries and registrars, who say, if you ask me to take down a domain name, you need to have a court decision in my country. That used to be the case for platforms, and one after the other, they have had to accept, particularly under pressure from Europe, but also other countries, that the national laws do apply to a certain extent. So the challenge that we're confronted with is basically how to manage the coexistence of different sets of norms in shared online spaces, instead of the beautiful separation of sovereignties that we had before. And I often say, the problem with the international system, and I have been the French Automattic ambassador a few years ago, the principle of international relations is non-cooperation. I insist. It's non-cooperation. And so the challenge is, how do you encourage the different actors to cooperate? Which brings to the situation which is today a legal arms race. In the absence of agreements and in the absence of frameworks that all the different actors can accept, everybody is trying to solve the problem with its own tools. So the companies are modifying their terms of service, the countries are adopting new laws, or they're trying to enforce their own extraterritorially. I don't have to paint the picture, we're all in the middle of this challenge. So this legal arms race at the moment is bringing a lot of legal uncertainty. And legal uncertainty is something that is extremely unpleasant for every type of actor. So the key question is, and I like very much the notion of to defer to something else, and then the concept of committee. The problem today is that, and this goes to the transnational cooperation idea in the end, we need to find the rules that determine how actors exercise their powers in a responsible manner. That means when they have an extraterritorial impact for a government, they need to take into account this. When the companies are developing their terms of service, they need to take into account the benefits of the different actors and the set of values. The key challenge, and I come back to the distinction between governance off and governance on, we have a pretty developed institutional ecosystem for the governance of the internet. And we don't have the equivalent for governance on the internet. We have a lot of different institutions, but none that bring people together. Internet and jurisdiction is where we try to bring those actors together, and we'll have a conference in November to bring them to discuss this. But I want to finish, and the conclusion is basically, we're here at the heart in Silicon Valley of innovation for business and for technology. I want to put a challenge to all of you and to all of us that there is an exciting field today, which is innovation in policy and innovation in institutions. And fundamentally, that's what we have to think about. And that's the exciting part, is that we need to invent new mechanisms that are not completely different from the past ones and build upon the previous ones and use them to be basically the structures for governance in the digital age, and not governance on or off, but how is governance in the digital age? And I don't elaborate, but I like the connection with the technology. The last point is, when the printing press was invented, it produced a lot of things, including the 30 Years' War in Europe, but it also produced the democratic representation and the representative democracy system. I think the technology that we have all invented is actually bringing new tools for a new type of democracy, and that's part of the challenge.
Sure. Yeah, thanks. Thanks. I have a little different perspective, I think, than most on the panel, because I think most of my day is spent kind of sorting out the real world mess of all of these doctrines and jurisdictions and borders that are sort of colliding. So in reading Law and Borders a couple times over the past few weeks to kind of get into the frame of mind of speaking here, I was really thinking about what is the role of where I work, of Automattic, of WordPress.com, of a platform that exists on the internet. How do I approach that role as a lawyer and manage these conflicts? And what are sort of the tools that we use to do that? I think the role of our platform is sort of interesting, because in the article it talks about, I think, two things. One is sort of this frontier within cyberspace that's very diffuse and self-governed, and then on the other side of that border you have the more traditional world of borders and physical world and state and laws. We as a platform are interesting because we're sort of right on that border. We exist in both places. We definitely have a community, WordPress.com in our case, and Facebook, Twitter, and others that exist completely within cyberspace where we make rules, we enforce those rules for the platform, and we all have different ways of doing that. We all have different values that we choose to advance that go into making those rules. But at the same time, we also have employees in the physical world, and we pay taxes, and we have assets, and we have servers and data centers. And these types of things, I think, that exist within the physical world give us sort of an interesting role to play. I think one is as a sort of as a choke point where a government may not be able to reach out and even identify an anonymous user, for example, that's blogging on WordPress.com or tweeting on Twitter, but they have a mailing address for me where they can send a subpoena for that information. And they have the address of my officer that lives in Ireland that they can arrest, and they tried to do that last year. They have my phone number, and they can call me up. They have our IP address range, what they can block within Turkey, for example, or Russia. And so we find ourselves in this very uncomfortable position sometimes, I think, but it also gives us a lot of opportunity as well because besides just being sort of a point of failure, I think, for these rights, we also have more power, I think, than an individual user might have. And we can use that, we can do a number of different things with that power/responsibility. I think we can be somewhat passive and follow the law, or we can sort of use the law as a tool to advance our values. And I find that that's the position I think we as Automattic, myself personally, find ourselves in where we use the law, we have a sort of set of values, I would say, that's not necessarily a creature of any one state, and we're sort of using the traditional law in the, in the physical world to sort of advance those values. I think U.S. law, for example, is one that is typically closely tied to things like free expression, and so oftentimes when we're fighting jurisdictional battles, et cetera, we find ourselves trying to advance that as our jurisdiction of choice, but that's absolutely not always the case. And within the U.S., we fight many battles in terms of copyright, for example, and surveillance over the last couple of years, which has been a strong point of disagreement of the law within our own country. So I don't think it's really tied to one specific place where we as a company live. Automattic itself is actually really interesting because we're a distributed company. We're not really based anywhere. We don't have a headquarters. We don't have an office. We have 500 people in more than 50 countries. And so it gets very interesting just from a jurisdictional perspective with that overlay on top of everything. So I think I would just close by saying that I definitely feel like as a company and as a platform in this space, we're very much on the frontier, and these battles that we're fighting, these jurisdictional issues that come up are, I think, like I said, we try to advance our own values and our own sort of take on these rules. And I think it's very interesting that the cases you hear, it's like Google Spain. It's not U.S. versus Spain, even though Google is I think closely aligned with sort of these U.S. values of free speech and free expression. It's the companies that are really fighting these battles, and there's definitely, I feel, a vacuum where we have not yet reached the point where the states that sort of have interests in these values as well are having that conversation or are fighting those battles on their own. It really is left to either an individual user or, as in the case of, Facebook, for example, and the whole international data transfer mechanism wasn't precipitated by two governments that had a disagreement. It was somebody that lived in Austria and they sued Facebook, and it was kind of played out on that company level. I see that happening over and over again, and I definitely see that day to day. It'll be interesting to see if that kind of rises up to the more state level. But until then, I think it's very unsettled, a little bit messy, but a lot of opportunity as well for a company like us and much bigger ones to really take an active role in shaping what the rules are.
Let me start. So, now at Daphne's wedding party, I'm looking out in the crowd and I'm like, oh, all these familiar faces. And so many of you who I have been in the trenches with to deal with Thailand and Turkey and Russia and France. So I feel like I'm in a double black diamond crowd and I don't actually have to talk that much. We should skip to the questions as soon as possible. So let me start with that. I'm also gonna double down on what Daphne said is like, not rehearsed speech, really not rehearsed. I wanna react a little bit to what all the other folks on the panel have said. I do have some observations, because getting to go back and read David and David's article made me reflect a little bit on like 20 years. 1996, like maybe you had a Gateway Solo 2100, right? Maybe you carried around a Trio or something like that, but like that was a long time ago. And in that time, this notion of cyberspace as a different place, I think felt a lot more real in the sense most of us probably accessed the internet sitting at a desktop, right? And it was a miracle to be able to see things around the world, or really mostly Europe and a few other countries, but around the world. And it felt like a portal into a different place. So that this notion that cyberspace was a different place and that we were untethered by geography seemed much more real. Here's an observation, though, I make that about today. We are all on some device that carries with us all the time. And the change in mobility and ubiquity has changed a lot about how jurisdiction and geography resonates with me on the internet now. Whether you are using Pokemon Go or you are hailing a cab on Uber, the virtual experience we are having feels much more tethered to the place I'm in than a place that I go to. And so I think that there's something that we need to account for in our framework of how we think about jurisdiction because of that change. I also think, like, so coming from 1996, and you mentioned the Yahoo case, France's extraterritoriality is still offensive to me, but it's not a surprise anymore, right? Remember when you heard about that case, like, France wants to like try and regulate an auction on Yahoo for the US? What are they talking about? That's insane. Nobody's surprised anymore. We're annoyed, but we're not surprised. And I think that is reflected in how companies, and actually I'd love to hear how Paul and Andrew think about this from their companies, right? None of us really go, oh, why would another country want to regulate me? It's more like, so what kind of defensive am I going to put up? Like, am I going to do geo-blocking? Am I going to be on domains that are specific? How am I going to localize? Where am I going to put employees, right? Like, there's a bunch of things that are fairly sophisticated, I think, with companies now about how we think about entering a market and availing ourselves of a jurisdiction that wasn't present 20 years ago. I think there's also that. I will say, and because I know some of you are fighting these fights for us, my perception of how things are going in the tech community, a lot of these smaller companies are terribly, they are not prepared to step into the fight necessarily. That takes a lot of resources. That takes really good people on the ground that you need to pay. So the fights are being made by the big companies. It is Google, it is Facebook, it is Twitter. And when you fight, you raise the defenses for all of us. And when you don't, everyone else retreats into the foxhole. So I think that is also a dynamic, which probably actually did exist back in 1996, right? Like, we all relied on AOL to go and fight every single Section 230 case, no matter what it was about, because it protected all of us. And I think we have a similar dynamic in that fight today. So I'll end with this one, which is, there's something about fighting with governments which has also sort of receded for me, and I don't know if it's just because I'm jaded or I've been doing this too long. Like, the fights with governments seem manageable. And what I sense in a lot of the companies out there is that their biggest fight may not necessarily be because I got to deal with this government, but actually a real internal wrestling with, I've got to deal with my users, and the polarization of my users and the invective that is currently on a lot of these platforms is almost a bigger fight than some of the jurisdictional things I have to deal with. Because it's not, a lot of the content issues I'm dealing with are not about what's legal, but what is civil. And I think that I'm not actually making a judgment about whether that's good or bad, but I think it's a difference in the last 10 years in terms of where companies are focused.
So I'm going to make one point about technology, but before that, I just want to tell a story about your paper, which hadn't even occurred to me until I was sitting here, which is in 1996, I was a cub lawyer working for John Morris at a law firm in DC, and we were challenging the Communications Decency Act. And your paper came out, was published. I think I may have even seen a pre-publication draft, and there was so little writing about the internet at the time, and at the heart of this case was trying to explain to judges who didn't know anything about the internet how it worked as a technical matter. And your paper did such a great job of that that I remember actually having, like, eagerly memoing it up for John and wanting to cite it. I can't remember if this was in the trial court brief or in the Supreme Court briefs, but I wanted to cite it because here was like a Stanford Law Review paper by authoritative thinkers. And I'm pretty sure, John, it was you who was like, we're not going to cite a paper that basically tells these courts that they have no ability to control what happens on the internet. And indeed, we did not cite that paper. But I loved it at the time. It was such a great piece of work. So here's the one point that I want to make, which is this. The big change, I think, that has happened and that is fueling a lot of the shift in how jurisdiction is being asserted over the internet right now is that we have seen a move from the edge to the core. Power has shifted from the edge to the core. And so in the history of computing, you basically have this like yin and yang of core to edge, right? So initially we had like big mainframe computers and very stupid terminals. Eventually, by the time the 90s came around, we had like really smart PCs that were networked with each other, but there were very, very thin machines in the middle. Then the rise of the cloud and these incredible structures of data processing and storage that we see in the data centers of Google and Facebook and Microsoft and these other large infrastructure providers, they've allowed these things to basically, powerful though they are, be the dumb terminals of our age. So we run software on them, or to the extent Apple allows you to run it on your iPhone, we run software on them, but the bulk of the power lives in the core of the network. The reason that is significant is because it has given governments that are increasingly interested in asserting their own jurisdiction, asserting their own proclivities, asserting their own rules, a whole new landscape of targets to go after. They can go after the operators of those services in the middle. And I think one of the things which is so interesting to think about is what will happen as these things get increasingly powerful. The bleeding edge of the counter-cloud reformation is encrypted applications that make the data very difficult to read from point to point, but that's just sort of like the bleeding edge of what might come. I'm not sure it's too crazy to imagine that someday the entire Google search index will be able to fit on one of these. There are deep questions about whether Moore's law is about to peter out and CMOS computing will reach the limits of its ability to sustain that trajectory of increased computing power and chips. But one of the things which I think is interesting to think about is what happens when governments lose the ability to go after data at rest as a way of asserting jurisdiction across the borders. And so, the two great axes of conflict on the internet right now, the ones that are the most prominent anyway, are censorship and surveillance, or if you want to think about it more positively, free speech and privacy. And so these two conflicts are arising, interestingly, Not so much in countries that are super restrictive, like China, because they really are content with containing their regulations within their borders for the most part. The transnational application of national jurisdiction tends to be, it tends to take place at the behest of governments that are more or less democratic, but have different views about speech, for example, than the United States with our First Amendment. So countries like India, you mentioned Turkey, Thailand, France, Germany, Brazil, they are countries that you cannot discredit as undemocratic or authoritarian, however flawed their democracies, like ours, may be. Instead, they're countries that really do have different points of view, and it forces us to contend as companies with the extent to which we want to vindicate normative values, universal normative values, for example, of freedom of speech, which we Americans like to flatter ourselves thinking that we stand for, which I do believe we stand for, versus respect for the absolutely legitimate democratic exercise of power expressed in law that says that, for example, in India, insults to other people's religions are forbidden, not in order to oppress them, or at least that so goes the expressed rationale, but rather to ensure coexistence across diverse groups that have a long history of killing each other on a regular basis. So anyway, those are the interesting things to me, and what I would love to see is, what I would love to do is to sort of project forward and think about how a shift of power back to the edge might once again jeopardize national government projects of asserting jurisdiction over free speech and their ability to conduct surveillance.
So I asked the panelists to each think of a question for each other, but then I forgot to remind them at the beginning. So you're certainly forgiven if you didn't come up with questions for each other, and I imagine we will readily come up with audience questions. But I hope that some of you do have, that said, I hope that some of you do have sort of thoughtful responses to things that the others have said. David Johnson?
I have a question for David Post. You've argued that we should not use the ICANN control of the domain name system to police content on the net. And my question is, if there really were a global consensus that a particular kind of content should not be allowed online, would you still not allow the use of that technical lever based on an actual showing of consensus to shut down particular kinds of content and sites?
I don't know what such a consensus would look like, a sort of global consensus on some form of speech. But if there were such a thing, and I suppose you could say there is with respect to some forms of child pornography or sex trafficking, for instance, and if ICANN, with the levers of the power that it has, were able to design a system, to implement a system that could effectively deal with that speech, I don't have an objection in principle to that. I think what the objection is that is, it's so easy to imagine that system bleeding out into other forms of, to impact other kinds of speech over which there's not a global consensus, which covers virtually everything. And we lose, I thought Bertrand said it well, or maybe Nicole, that the goal is to sort of maintain the respect for the diversity of these values. Andrew's saying this also. I think we sort of agreed about that on the panel. That the challenge is how to design a system that is not in the core, that is not centrally designed to impose a particular view of speech on the internet actors, but to allow different communities to have different, to implement their own values while still maintaining sort of the free flow of information across the network.
I would follow up on what David is saying about sort of the risk of exceptionalism for particular worst of the worst content, which usually means child pornography. In practice, you know, there are systems that, for example, do duplicate detection and automatic filtering for child pornography, which most people think is a good thing, but once those technologies exist, it is much easier for a plaintiff to go to court and say, hey, the company can do it, so they need to do it for me for this additional claim. And so the sort of bleed into other areas can proceed really rapidly. Are there other people on the panel?
So I have a question probably for the whole panel, but particularly David Johnson, because you talked about the cosmopolitan pluralism, which I love the idea, and it may just be this particular moment in the election cycle, but it doesn't feel like we are in a place where we can get everybody to the table to say, there is a greater good that we will all adhere to. And I say that partly because the election revealed like apparently a part of our population that doesn't believe in peaceful democracy anymore. But I think that's global, right? Like there are certain pockets of constituencies, some of which are not even state-based, right? They're interest group-based and they're cross-jurisdictional, who are not seeking comedy with any of us, but dominance. And so I guess I wonder, for the whole panel, what is your optimism about getting people to the table on a similar set of values?
I would say briefly in response to that, comedy is not the same thing as harmonization. And I share your assessment that it's going to be very difficult to get everyone to agree on anything but the most extreme cases. What a claim to comedy is a claim that a particular court or jurisdiction should not impose its rules on another rule set where that rule set can claim that it really is speaking on behalf of the parties who are affected. So when I say I think Facebook can, or WordPress can go into court and say, you know, we're closer to this problem, we listen hard to the people who are speaking and the people who are affected by what's being said. So you, local court, you, local legislature, really should not be imposing your rules here. Now, that's a normative position. I'm not saying it will always be respected, but at least there's a high ground that can be seized by the platforms, is what I'm saying.
Yeah, actually, we're touching upon a very difficult coexistence of the different actors. One of the challenges is that we have a tendency to think that a framework for coexistence of these different rules requires some form of harmonization on substance. What I strongly believe from all the discussions that we've facilitated in the last few years is that the real angle for progress is interoperability on procedures. It's bringing due process across borders, because the current situation is that the interaction, as was mentioned earlier, is mostly between public actors and private actors across borders, which is something that we normally don't do so much into an international system. And there are more and more direct requests that are being sent by public authorities in one country to a private actor in another one. And you're a perfect example, but currently, those requests are being done with all shapes and forms and no particular framework, and according to criteria on both sides that are really, really strange and fuzzy, to say the least. And so I think it is really in everybody's interest to be able to develop those procedural frameworks, because it protects the companies, it ensures the users that there are guarantees and procedures, and it allows the governments to, when they are pursuing a legitimate objective, which can be to fight crime or to fight abuses, that they have an avenue for interaction. And this mechanism of bringing people on the procedures is probably the way to build trust and bring confidence-building measures. But harmonization on substance, especially on speech, is a no-go. We could talk about the question of ICANN, because it's actually a problem that is currently being discussed on whether there should be a takedown of a domain for the content that is on the site. And the question of whether it should be in the mandate of ICANN or not is a very hot topic at the moment, and it's one of the issues that we'll address in November.
Mm-hmm. Andrew, you've been twitching.
No, not quite.
Yes, you were.
Not quite twitching. Okay, I have a question for Nicole. So now I have a question back for you. So on when you think about the Yahoo Nazi auction case, what's more irritating? The fact that we're still talking about it in 2016, or the fact that the French student group's arguments have basically proven to be right. And what I mean by that is that the French student organization's arguments have basically proven to be right. In other words, back at the time, a big part of the argument that we had was, IP geolocation so inexact, you can't possibly control the flows over borders. But companies that we've worked at have built unbelievably sophisticated targeting systems now to deliver advertising, to recommend content, to provide friend recommendations, to cabin the flow of speech within their own platforms, that it's now completely untenable to argue that we can't control with extraordinary precision the delivery and accessibility of certain kinds of speech to certain kinds of people in certain kinds of countries. What's more irritating?
That's such a hard choice. So I think it's the first, right? Just because I would have hoped that we got to a place where government sort of respected what the separate laws of separate countries and came to a conclusion. What I was hoping was like, we'd all come to a conclusion, we'd figure out how to deal with speech that made other people uncomfortable, but it would be more liberal, as opposed to, right, what has happened, which is we can really specifically identify the geolocation of a person, and we can close up the wall, right? Like that we can reborder ourselves, that we can do what many of the governments are asking us to do, which is localize the data inside their country so that they can fully control it. That has been the drift of it, is a technology progression, and I'm not sure we were capable of stopping that, but we were certainly capable of having the leadership to say, we have a higher value in terms of respecting each other's different content values, and we aren't going to go press for them.
So just to add a note to that. So I think I'm totally with you on this one, which I think the interesting thing to think about is that there has been this rising tide of governmental demands for what's called data localization. So storing data locally within the physical boundaries of a particular nation state. And that is not so relevant for censorship, because for all the reasons that you mentioned, the systems are in place to either enforce or not, depending on what the platform, the holder of the speech wants to do. But it's super relevant for surveillance and for governmental surveillance. And we have argued for a long time among internet companies that if the data is not within China, then China can't ask for it. If the data isn't in Malaysia, the Malaysians can't ask for it. And so governments are like, well, fine, we will require then that the data be here so that we don't have to go through irritating MLAT processes in order to get our hands on it. And so this violates the basic principle of the internet that we've talked about before, which is its generally borderless architecture, because it tries to confine literally the data itself on machines that are accessible to people benefiting from the monopoly of force and able to get a court order and able to go in. And so what I think is interesting is that it'd be nice to think that governance on the internet and governance of the internet were continuing to operate towards a broad system of comity and coexistence and so forth. But governments don't really care. They're saying, nope, the data has to be here local. We have to be able to get access to it under our own rules decided by us, and timing and through means decided by us. Otherwise, you can't offer your service in our country. And they are therefore using exclusionary tactics or the threat of exclusionary tactics in order to enforce physicality of the network.
Yeah, to put some context on it, right? Like, we started hearing about data localization for several years, but most particularly post-Snowden, right? So like the sudden realization by all of these countries, like, the Americans are on our internet? Why don't we have that information, right? And so all of a sudden you had many calls for saying like, put the data here, where I don't have to go through MLAT, where I don't have to be transparent about the type of access I have to all that content, and I can shut it down immediately if I feel like it's getting out of hand. So the level of government control comes with that context. It also, in that moment, revealed to me that governments are, I knew this, but it highlighted, governments are not monolithic. So that even if you had a commerce department that desperately wants us to have the free flow of information so that content and commerce goes around the globe freely, your national security apparatus in that same government may not feel the same way, right? And so like there is work to be done at a national level, and then there is work to be done at a global level.
Paul, did you want to respond?
Yeah, no, I think picking up on all this, I mean, I think the data localization, it's definitely true for the data, but I think it's also true for the content, just in the sense that a court in Turkey, for example, could order Automattic to block a site, and we can say no, but if we do say no, they then go to the ISPs within Turkey. So they actually do have a level of control over our content that we don't really, I mean, we have that control as well, but they can impose their will on that as well. And so I'm actually pretty pessimistic. More countries are doing this, by the way. I think the trend is that, 5 years ago, it was basically China and then the rest of the internet. But now, I mean, we're seeing a very much of fragmentation because of this power that the ISPs within certain countries are forced to block certain parts of the internet, certain pages that we host, all of WordPress.com, for example, if we refuse to take something down. And I think that will just be accelerating more and more to the point where, you'll have, a Turkish internet that's different than the French internet. But really, I'm optimistic, if anything, just about perhaps a technological, whatever the technological workaround to that is. I mean, I think right now, if you have a decent VPN, you can kind of circumvent a lot of that. And so we have the internet and then a bunch of kind of subsidiary ones underneath that. I think that's going to happen more and more and more as countries start to get, or courts, legal systems start to get more intelligent and sophisticated about the levers that they have right now, but they maybe are not aware that they can control.
So I think we should shift to audience questions, but I just want to ask, following up on what Paul said, how many people in this room have been either the sender or the receiver of the email that goes, hey, do you know any good lawyers in Turkey? Maybe we just all send them to each other, yeah. I know there's someone out there who sent this to me in the past week. All right, Mike, you had your hand up from way back, and then we'll pass it.
Just a couple of notes. Very briefly, David, the Davids were discussing whether there were consensus crimes where, what you might do if there were sort of an international consensus that certain things or certain kind of speech should be prohibited. I just want to point out that the Budapest Convention, the Cybercrime Convention, actually sort of reflects an effort to try to get international consensus. But oddly, although child pornography, unsurprisingly, is there, the other thing that's really there in terms of substantive prohibitions is copyright infringement, which seems odd. Because in terms of scale of wrongness, it doesn't quite seem like the same malum in se, right? So I wanted you to comment on that. And secondly, with regard to one of the things that I noticed that's common, and it's common in lots of discussions, is in transborder discussions, is the idea that the place is the thing that is analytically the important thing. But in fact, what we try to do in United States law, and what there have been some efforts to do in international law, is to talk about human rights as distinct from what the place is. So I wanted to know if you wanted to comment on that. I mean, that's a Katz versus United States for American law geeks, but places not, persons not places is what the protection ought to be aimed at. And I wanted you to comment on that.
Please. I guess I agree that the important question is whether there's a demonstration of agreement among people that certain rights ought to be protected. And just to try to introduce a note of optimism, the Net Mondial conference, it seemed to be demonstrated very widespread support for a free and relatively open, albeit pluralistic, sort of internet, and general support for the proposition that governments should not be the only source of rules, and that rules shouldn't only be based on local territories. So, but I think the burden is still, the question is still out there. Will a global polity emerge? And if it doesn't, we then will be more territorial than previously, and I don't have an answer to why copyright law gets all this special protection.
Does anyone want to answer the copyright one? It's just a mystery. Nobody knows.
Right. How heavy is that elephant that's sitting in the room over here? I mean,
One might suggest that, as a hypothesis, that the copyright industries have been notably effective in international forums at advancing international protections, and bilateral and multilateral treaty agreements. It's just a hypothesis.
Right.
And I think there's also a legitimate case to be made that copyright is relatively internationally harmonized. Certainly by comparison to defamation law or privacy law, it's more likely that the outcome of a claim will be the same across borders in a copyright case. Hello, sir.
Hi, I'm Andrea Glorioso from the delegation of the European Union to the US. I missed the very first 10 minutes, I think, of the panel because of a nightmare GPS situation with Uber, and I'm heavily jet-lagged, which means that even if I was here, I might still have missed something that you said, so apologies for that. But I wanted to touch upon something that NICOLE WONG said about data localization, and this notion that data localization runs counter, if understood correctly, jet lag allowing, runs counter to the spirit of the internet, because one of the core principles of the internet is that data can be accessed from any other point to any other point. And my point is that, in fact, even if that is true, so-called autonomous systems on the internet always had the ability and the capacity to decide autonomously, hence the name, which data would be accessed by third parties at any given point in time, which traffic would flow into their system. So the question is not really, from my point of view, that one of the core principles of the internet is data should always be accessible. It is potentially accessible, and it is up to whomever has the autonomy to decide whether that data should be accessed or not. And this leads me to the point / question / comment, whatever you want to react to, which is something that I think David Johnson raised because you mentioned it in passing, that public authorities and courts, in the example that you gave, should give comity to private companies and private entities. And that is not I'm not saying I have an opinion on that, but that is not the definition of comity that has been existing in international law for a long time, because under the rules of comity, you give a comity to your peer, which is another court, and the executive gives comity to another executive. So I think perhaps we should explore a bit more, who are we actually arguing that in order to solve the problems that we have to solve, we have to raise the role of private entities to those of public entities. Again, I don't have an opinion. I will say, though, that you will have to convince a bunch of citizens that the Coca-Cola company has this, to just make one example, and I could make European companies examples, has the same powers and prerogatives and deserves the same comity as a democratic government.
Well, I'd like to use that comment to go back at Bertrand's suggestion that he suggested that the question of whether ICANN should use its contractual, ICANN, a non-governmental private nonprofit, should use its contractual powers over registries and registrars to tell them that they must take down a domain name if certain kinds of content are hosted under that name. I had thought that we had resolved that question with the new bylaws that were adopted as part of the accountability system, and so I'm worried now as to whether or not we have to relitigate that case. But I quite agree that the case made by a private entity that it can set the rules and that those ought to be respected by government is not a trivial case. It's not normally the way governments look at things. So there's significant work to be done for Automattic to be able to go into a court and say, you know, you should not interfere with the way we run the rules of our online space. I agree.
Bertrand and then Andrew.
Yeah, I'd like to make two comments. One of the problems in those things is that there are so many different elements that are floating around, and it would be too long to open the ICANN case. But I want to reassure you that it's not. If that's what you understood, this is not what I meant. Yeah. So. The new bylaws say that this is not a topic for ICANN to deal with content, but it's a more complex issue, and there are voluntary regimes. I wanted to say two things. One, maybe to Andrew, and I'm often the European or the non-American on a lot of panels here, so it's a pleasure. And I think what irritates me most, as you were asking, is the fact that people are still irritated by that. I mean, there is an election in the United States, but there's also going to be an election in France in a couple of months. There was a primary for the first time in France, and one of the candidates at the end said, to promote what she was putting forward, nostalgia is not a project. The United States actors should try to avoid thinking that the beauty of the unified internet, which was open to all, is going to come back, because actually it was the way you feel it was because it was under US law. So there's a problem, and I understand perfectly that it's unpleasant when the boomerang is coming back on the other direction. But what we have as a common challenge is to find a way for the coexistence of these different laws. And I like very much what Andrew was saying. There are a lot of situations in very democratic countries where local history, local sensitivities have led to the adoption through absolutely democratic processes of laws that are an identity for those countries, just like the First Amendment is an identity for the US. And I want to say, if you look at the implementation of the First Amendment, if you look at the jurisprudence, the reality is that the application of the First Amendment in the US is not so far away from the way it is implemented in many European countries. It's the starting point and the principles that are further away. But we shouldn't be absolutists in this regard, and we need to move forward. And the second thing is, when you look at the companies, and I have looked at that very closely, in the last 5 years, there has been a tremendous convergence of the terms of service among those companies to precisely accommodate this. And the reason why they do this is because the de facto role of the companies today is they are the only actors around the world who care about a form of harmonization. Why? Because they want to have terms of service that are applicable in as many countries as possible. And therefore, they are taking the huge burden of having to manage the formulations to get to something that is as close as possible to something that is acceptable among democratic countries. The big challenge at the moment, and I finish with this, is that this has put them also under pressure from a lot of countries, democratic ones and non-democratic ones. And the arrangements that they are obliged to make after terrorist attacks, after all kinds of problems of crime, is that they have no way to say, we stop here instead of there. And the danger is that they could be dragged further and further because of the need of accessing the market. The best solution for them is to get out of the prisoner's dilemma, and that goes for governments as well, to get out of the prisoner's dilemma where everybody is feeling that things are going in the wrong direction. But until people really get around the table and say, listen, we have a common problem, how are we going to tweak some of the elements that we're doing so that it is acceptable for everyone? There's a sort of bargain. The companies need protection. They need to have a reaffirmation of the non-liability regime, because at the moment, the pressure is towards responsibility. It's towards monitoring. It's towards active, proactive monitoring. And actually, the copyright environment has been extremely instrumental in promoting GeoIP filtering, in promoting automatic detection, and all those tools are now available for basically saying, well, of course you can pick the terrorists because you can know how copyright infringement is done. So I think it's very important to understand, and finish on this notion of committee, and to Andrea's remark, I want to make an analogy and share it with you. In physics, if you want to build a bridge today, in normal conditions, you still use good old Newtonian physics. If you do something that goes to close the speed of light, or if you do satellites and so on, you need relativity. For jurisdiction, it's the same. If there's a Frenchman insulting another Frenchman on a French platform in French, and they all live in France, it's absolute national sovereignty, French law, period. If, however, this very same Frenchman is traveling in Los Angeles and posting something that is anti-Semitic against an Iranian that is based, I don't know where, in Australia, I'm sorry, there's an element of competing jurisdiction. Who has authority on the case? Who has authority on the location of the person? And Dan Swanterson was here, has made a lot of comments on how do you combine the territoriality criteria that now are multiple. And so the point I wanted to make is, this is not about whether the companies are superior to the governments or the governments are superior to the companies. It's about how they can co-develop the rules in a way that is satisfactory for all. And I want to quote one sentence from the paper, which at the time said, both sysops and users have begun explicitly to recognize that formulating and enforcing such rules, for subparts of the internet should be a matter for principled discussion and not an act of will by whoever has control of the power switch.
So Andrea's provocation is perfect, actually, because it really points out something that I personally, and I think at least this side of the table, struggles with tremendously. All through the ICANN process, I remember hearing this prickly bristling of particularly European participants from governments saying, why is anybody other than a government sitting around the table here? And the notion of a multi-stakeholder process in which lots of different actors could be heard and represented overcame those objections. And I think it's a credit to people from a much more statist tradition that they have come around to see that that democratic institutions are not the only way to properly express preferences and views and achieve a good outcome. One of the things that I think is so interesting about the paper, though, is that it's in calling out the notion of cyberspace as a place. One of the legacies of that that tradition, that sense, that feeling from the early internet days, is that many companies view themselves as not just Coca-Cola, right? Like many of the companies and the people that work at them view themselves as fighting for a set of values around free speech, democratization of power, and so forth. We betray these values in many ways. We undermine ourselves. The competing claims of capitalism and free speech, come into conflict. But nevertheless, we view ourselves as standing for a set of values. And so where this has really come into relief for me lately is that sometimes those democracies whose peculiar proclivities we're saying we want to respect, sometimes they produce terrible outcomes that run directly counter to our values as internet people, as citizens of at least this notional place. And the one that is first, sort of foremost to me right now is the right to be forgotten. It is so horrible as a principle. The idea of Stalinist, censorship of historical truth because of the views of some bureaucrats in Brussels now infecting the continent. I mean, nobody would accuse the European Union of being a democracy, I say provocatively. But it is nevertheless the outcome of a collection of democracies choosing to pool their sovereignty in certain ways, and has now created what I think is the most monstrous policy to come out of a democratic institution in decades. And now we companies are the ones that are being asked to go and enforce censorship of historical truth simply to protect European elites who don't want embarrassing information to be present on the internet. And so we struggle then. I can talk about cases where national preferences are rooted in history, express cultural values that I think are enormously important to respect, and where I very much want the institutions of democracy to be strengthened and respected. But I also can come up with these examples where those same democratic institutions produce really, really awful rule sets that I think are to be resisted, are to be fought, are to be contested, and warrant evolution in the architecture of the internet such that we can overcome them and liberate the speech and the privacy that we want to see from the repressive nature of a democratic institution producing a bad outcome.
So we will have a panel on the right to be forgotten this afternoon. Andrew is not allowed to talk on it.
I've said my piece. I have nothing more to say.
We have spokespeople for a wide array of positions, including Matthias Moulin from the French Data Protection Agency, who will mount a thoughtful and nuanced explanation of their position. We also, going back to this question about companies' power, the final panel of the day, what I've been calling the Realpolitik panel at 4, will address exactly that question, sort of to what extent is national law displaced by the actions of companies or their community guidelines? Is that a good thing? Is it a bad thing? But I think one thing that's important to bear in mind is that while regulating online speech through an instrument like a private terms of service or private community guidelines is convenient, it's convenient because the company can actually enforce it, and it's convenient because a company can come up with rules that are some kind of average or lowest common denominator of national rules, and that reduces conflict. There are all these things that make life easier if you look to companies in terms of service as a source of regulation. But it doesn't seem to me that you would want to treat companies as in any way parallel to states, not only because they're not democracies, but because they don't have the mandate of a state to protect the interests of the people, and they don't have the legal constraints of a state to honor the sort of human rights obligations that are set as obligations of state actors rather than private actors. So I think it gets really complicated, and we'll have a good talk about that later.